Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing the federal government's invocation and then retraction of the Emergencies Act in response to the 2022 trucker convoy in Ottawa. The Emergencies Act is a piece of extraordinary legislation available in very specific circumstances that gives the government special powers, like the power to create new criminal offenses and police powers, without recourse to Parliament, advance notice, or public debate. The charity that I work for, the Canadian Constitution Foundation, is taking the federal government to court over their decision to invoke this extraordinary legislation. We say its use was unjustified, illegal, and unconstitutional. But in order to answer the important legal questions about the government's use of the Emergencies Act, the court needs to have access to a full and complete record. But the government is refusing to disclose key documents that explain why they invoked the Emergencies Act. We're fighting this in court and seeking access to those documents. Here to explain the important development in the case are two lawyers representing the CCF, Sujit Choudhry and Janani Shanmuganathan. Thank you both so much for joining us today. Let's start from the beginning, Janani. On what basis is the CCF challenging the federal government's invocation of the Emergencies Act?
So what the CCF is doing is we are bringing a judicial review in federal court to say to the court that the federal government did not have the requisite reasonable grounds to invoke the Emergencies Act. The Emergencies Act is meant to be an extraordinary piece of legislation, and we say that the courts, the police, the federal government, they already had the existing powers that was necessary through the existing criminal laws.
So there's these documents that we're seeking that are supposed to explain what the federal government was thinking, on what basis they invoked it. Sujit, what can you tell us about those documents that the CCF is seeking access to?
So there's a few different kinds of documents. There are submissions that were made to the governor and council or cabinet. So those would be recommendations, a policy analysis. Then there's actually a draft of the order in council. We'd like to see, for example, if the order in council that was proposed is the same that was adopted. And then crucially, there are the minutes themselves of the cabinet meetings. And the minutes, not just of cabinet meetings, but also of something called the Incident Response Group, the IRG, which is a cabinet committee that was created by the Prime Minister in 2018 that met on almost a daily basis throughout the trucker convoy protests, and also during the state of emergency. And the reason we need those documents is to better understand why it is that the government felt it had a legal basis to invoke the act. Go ahead,
sorry,
please.
Sujit, I'm just wondering how they would help assess the legality of the federal government's use of the act. And kind of they've provided some public documents, but are those documents insufficient to explain it? Why do we need more information?
So the way this legal proceeding works is that the court has to decide whether the government had reasonable grounds to issue the public order emergency based on what's called the record. And right now, the public record is very thin. It basically consists of a single document filed at the House of Commons. And in relation to the legal justification for invoking the Emergencies Act, a single sentence in that document. And so it's far from adequate. And so we say that for the court to be able to do its job, it needs access to all of the materials that were before cabinet, not just the document filed in Parliament.
So they're refusing to disclose these documents. Janani, what is the basis on which they're refusing to provide these documents to the court?
So there is a provision in the Canada Evidence Act that allows the federal government to assert something called cabinet privilege. And so this covers discussions that took place during cabinet meetings, at cabinet, while they're making the decision. And it also covers the documents that were before cabinet when they were making this decision.
So obviously, cabinet confidence has been invoked in the past. We've got to go to commercial break now. In other cases, cabinet confidence has been invoked. I want to talk about some of those examples, some precedents, if this has ever been used before, and if there's a way around it. Because really, in order to challenge the government's invocation of this act, the government needs to present a case of why this was justified. And right now, there's not a whole lot of information. So we got to go to break. But when we come back, we will discuss all of that.